of the course is about subpoenas. I want to make really clear that this section is for informational purposes only and is not legal advice. I am not a lawyer. But there's a lot of misinformation out there, and I thought it might be helpful for people to have an overview and a context for it. I totally believe that if you get a subpoena, the first thing you should do is contact your malpractice insurer and let them walk you through it. Depending on the situation, they will provide a lawyer to assist you. That's what you're paying them for. They are motivated to protect you. I've had several subpoenas for depositions, and I had a lawyer go with me who was wonderful and offered me so much support. So, of course, you want to hope that that doesn't happen, but if it does happen, you really want a lawyer with you. So, what are the factors you need to take into consideration if you receive a subpoena? So, our ethical responsibilities, HIPAA regulations, California state law, the client's feelings on the subpoena, because sometimes they just might say, like, go ahead, testify, or release the records. And if you work for somewhere, any agency policy. So your ethical standards on confidentiality, I'm not going to go into in depth, because I think we all know that we are ethically responsible to keep our clients' information confidential. That's just one of the most important tenets of our ethical responsibilities. So I have all the very specific information in the packet for you to read, but I'm not going to read it to you. As far as HIPAA and confidentiality and subpoenas, there's some other stuff that comes up. The privacy rule states that in order to respond to a subpoena, you must either have a court order mandating a release of records, receive a written document from the client agreeing to said release of the records, or receive documentation that reasonable efforts were made to contact the person whose records were being sought. In general, what we are always going to do is get a court order or a written release from our clients. What's privilege and how does it fit in? Privilege, this is a direct quote, privilege is a rule of evidence that refers to the right of the holder of the privilege to refuse, to disclose, and to prevent someone from disclosing confidential communications in a legal proceeding. So for a therapy client, they have the right to allow or deny their therapist to share the records in a legal proceeding. They hold their own privilege. If they invoke the privilege, the therapist cannot release any records without being ordered to do so by a judge. It's the therapist's job to invoke privilege and the court's job to decide. For a minor, the privilege may not be held by the parent, so the therapist needs to be in contact with the child's attorney, as that might be the person who holds the privilege. You want to understand who's holding the privilege for the client. There's a few exceptions to privilege. If a client has a case where their mental health status is relevant, they cannot keep records from being released. You're going to see that a lot, and I've seen it myself with car accidents. That mental health status is relevant, and they are going to be required to release records. Also, if they sue their therapist, they cannot keep records from being released. But you should always still invoke privilege if that's what the client wants. You know, why make those decisions? Let the court make those decisions. So, again, how does that work? The client waives privilege, and you, of course, want them to do it in writing. And they invoke privilege, in which they say, like, no, I don't want you to release the records, invoke privilege, and then the courts decide. For minors, the first step is always to assert privilege, unless the person who holds it for the child waives it. It could be a parent, a guardian, a minor's lawyer, a guardian ad litem. You must figure this out. The parent does not always hold the privilege. There's very few circumstances in which a minor can invoke their privilege. And, you want to, I would, again, just get some legal consultation in that if a minor is telling you they want to invoke their privilege or waive their privilege. For mentally incompetent adults, the privilege is always held by their legal guardian or conservator. So again, exceptions to privilege, I discussed those. Clients involved in a case where their emotional mental condition is an issue, or they're suing their therapist for professional negligence. Again, it's not up to you to decide. If they ask you to invoke, you do so and let the courts decide. The courts are probably going to decide that they can't, but again, not your job. What about psychotherapy notes? So those, HIPAA, how HIPAA defines it, are notes recorded in any medium by a mental health professional documenting or analyzing the contents of conversation during a private counseling session or a group, joint, or family counseling session that are kept separate from the rest of the individual's medical record. Psychotherapy notes exclude medication prescription and monitoring, counseling session start and stop times, modalities and frequency of treatment furnished, results of clinical tests, and any summary of the following items: diagnosis, functional status, treatment plan, symptoms, prognosis, and progress to date. There's a lot of people that are going to advise you not to keep psychotherapy notes. It can be confusing to keep them separately, and many times if there is a subpoena, you are going to have to release them anyway. As far as HIPAA and psychotherapy notes, HIPAA requires that if there is a subpoena, it must specifically name psychotherapy notes. And if a client requests their release, again, it needs to specifically name those notes. There has been a past court case where a therapist declined to release such notes and was ordered to do so in Evenson versus Hartford Annuity. Now, this is sort of an interesting case because the husband died, the wife ended up suing the insurance company for life insurance payout. The insurance company said he wasn't eligible because he wasn't truthful about his addiction history and went for his records. And the therapist released some, but not all of them, and did not release psychotherapy notes. She stated that because HIPAA states patients don't have the right to those notes, that they should not have to be released to a litigant. The wife actually signed a release for the notes, and the ending court decision was that she had to release them. So it was sort of more complicated because the wife also signed the release for the notes, and she was the person in charge after the husband's death. Subpoenas. What types are there? So there's a subpoena for records, and those might be mailed or served on you personally. Testimony, which could be a deposition or in a trial, and, a subpoena that calls out for both. My experience is you usually get the record subpoena first, and then further along in time, you get a testimony subpoena, unless it's a rush case, in which case you might get both at once. Options for responding to a subpoena when you have client consent. If the client wishes to have the records released, then you have them sign a specific statement to that effect. Full information on what's being released, and making sure that you know that they have been informed and understand any consequences to releasing the information. You may want to have in the statement that they're waiving privilege for the release. And, you can consult with an attorney into what should be in the release. Many subpoenas have such a release attached to them. I've had that experience where it was a car accident and the client had already signed a release. But for me, and just to be cautious, I personally contacted the client, verified that, and had them sign my release also. If the client does not consent, if you can't reach them or they tell you they want to invoke privilege, then you invoke privilege. And again, if you've consulted with your malpractice insurance and if you're invoking privilege, you definitely should. The lawyer they assign can do this for you. It's one of the reasons you want to get the lawyer involved, because they can take care of a lot of these complicated details for you. California code is very clear on this. Unless the client tells you otherwise, you must assert privilege when you're subpoenaed. So if you can't find the client, you don't have a release, you assert privilege. The Patriot Act, this is sort of a weird thing that's I'm throwing in there for informational purposes. There's not a lot of clarity out there because of the secrecy of the Patriot Act. But the Patriot Act, Section 215, allowed FBI agents to request subpoenas from a special court. No real limits on what could be requested, and if a therapist got subpoenaed in such a way, there were severe penalties for telling a client you were releasing their files. So not only did you have to release the file, but you couldn't tell the client you were releasing the file. In March 2006, there was some legislation that clarified and said that FBI agents could seek only information under this section if it was related to terrorism. And it also added that a therapist can now receive legal advice and fight the subpoena in a FISA court. So in those circumstances, obviously, you would then fight the subpoena. And of course you would get a lawyer, because this is very complicated. The APA did add to their ethics, saying that if you released records because of the concerns of the Patriot Act, that if you release such records, that you weren't going to be ethically sanctioned for it if you were otherwise following the law. California law and legal cases on confidentiality. So there's a very lengthy law on subpoenas. I'm not going to go through it in depth. You can read it in the handouts. Yeah, see how lengthy it is? Let's skim to the next session. Okay. So the actual Supreme Court case that held for confidentiality is called Jaffe versus Redmond. And this was a 1996 case in which Redmond was a police officer who shot a person in the line of duty. Jaffe was the executor of the dead person's estate and sued for the shooting. During discovery, it was found that Redmond had seen a licensed clinical social worker, so those records were subpoenaed. At that time, before this case, there was no privilege option, and if you did not release records, it could be held against the defendant, which is exactly what happened at trial. The court found against Redmond and awarded the estate $545,000. This was appealed first to the Seventh Circuit Court, and then to the Supreme Court. The Seventh Circuit overturned the ruling and said that each state individually recognized privilege. It was appealed again to the Supreme Court, who stated the federal rules of evidence established a right to confidentiality. Judge Stevens delivered the majority, 7-2, opinion and said the following. This case amply demonstrates the importance of allowing individuals to receive confidential counseling. If the privilege were rejected, confidential conversations between psychotherapists and their patients would surely be chilled. Your rights in California when being served, you have the right to be personally served. And, the thing with that is if you're served improperly, you can either just recognize the subpoena or you can make them serve you again. Okay, so that's your overview of subpoenas. In the packet, there is some references and some great articles in here that you might want to read and follow up with. And I hope this gives you a little bit more clarity in talking about subpoenas or understanding subpoenas, because I know they're very scary for many of us. All right, thanks for listening.